I normally respond to body cam things because they're funny and this and that, but this has really captured my attention. Is this Anthony Metcalf deal? And I practiced law for a while. I did prosecution work and I did defense work. So it's been interesting for me to watch. And what I sat down and did was I just put myself in the shoes of a defense attorney and in the position of the defendant to see if this really makes sense. And to me, it doesn't make much sense. The reason it doesn't make much sense is that the defendant has taken a lot of steps to facilitate this situation. And by that I mean that in preparing for the track meet, the defendant decided that he needed to carry a knife because it's in his backpack, in his possession at the track meet. It didn't fall out of the sky. It's not something he found on the ground. There's been no testimony as to that. Maybe they'll say it and that, he found it there and so he just put it in his bag. But I don't think that that's the situation here. That the defendant got ready for the track meet. The defendant put the knife in the bag. The defendant carried the bag with the knife to the track meet, not obeying school rules, right? So there's been no testimony that knives are common at track meets. In fact, it's a thing that all of them use to, prepare for their track races or anything. No, there's not been any testimony that they use a knife to change the cleats or a knife to do this or a knife to do that. There's been no testimony of the common use of a knife at a track meet. And so, you've got a problem there. One, that he brought a prohibited item to a place. And next is he carries it with him everywhere. Everywhere he goes, he's got this backpack. He's in a place that, is normally for the other team, regardless if it rains. There's not been any testimony that they saw him in the rain and that he was starting to melt or that it was causing him serious physical injury in the rain. That's a problem for his team. His team should get a tent so he could stand under it. All right? Or he can find shelter somewhere else. It's a sympathy thing. We feel bad for you, so stand under the tent. There's not been any testimony about that. The next one is the person that he meets, right? So he meets this person that he knows. And it's not like an immediate acquaintance. It's not a familial relationship. It's just an acquaintance from a girl that he used to date. And when he was dating that girl, he and this guy took pictures together, yada, blah, 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 wonderful. All right? So then he is there with this guy. Then he's told to leave, right? You need to leave. And then the situation starts to escalate, right? He doesn't decide, well, okay, I'll leave. He decides that he's going to mouth back, right? So he starts to mouth back, and this situation arises to a push. So he gets pushed, probably steps back, or everybody's been pushed. It's not a sympathy play. They're trying to make it a sympathy play, but it's not a sympathy play, right? So everybody's been pushed. And the response of the normal person when they're told to leave or when they've been pushed is to think in their mind, well, I'm not welcome here. Maybe I should find somewhere where I'm welcome. Well, the defendant decides to buck the system. He decides that it's a good idea to mouth back, right? There's been no testimony that he runs the place. There's no testimony that he makes the rules. There's no testimony that his presence in that location was necessary at that time. So a common, ordinary person would decide that they need to leave. But the defendant decides that he's going to escalate. And during this escalation, he mentally and physically has a knife with him. He mentally and physically reaches in, has it in his bag in a location he can find it. mentally and physically puts it in his hand, mentally and physically opens it, all right? That's a big problem, I think, for the defense, is that it's a folding knife. They may think it's a good thing, but I think it's a bad thing because it adds an extra step to the whole situation. He mentally and physically unfolds the knife. He mentally and physically removes his arm from the bag with the knife in his hand, still holding it. Mentally and physically, while still holding the knife, he mentally and physically thrusts his hand at the victim and causing death or serious bodily injury. So, I think in the situation of the defense attorney that you've got a lot of uphill problems. All right? And then he feels remorse after the situation happens, admits to the situation, admits to what happens. So we're really talking about the justification of the use of force against a push. All right? So he's given ample opportunity to de-escalate or walk away from the situation. He's been given ample opportunity not to carry a weapon to the school. He's been given ample opportunity to not carry the bag around with the knife in it. He's been given opportunity to leave a situation. So in all these situations where the word no is used, the defendant's decided that no is not his vibe. He's decided that everywhere he goes, everything's going to be yes to him, right? Yes, I can carry a knife. Yes, I am going to stand here. Yes, I'm going to stand wherever I want. Yes, when I kill you, that it's okay. Well, it sounds like this gentleman has never been told no, or no has never been enforced against him. So then let's step over and let's do it on the prosecution's side, just according to the facts. And, you know, the law is what the law is. And I'm not going to take the time to read over the boring law. You can look it up. We're just looking at the facts and the actions. All right? Prosecution laid out that he was present. All right? Prosecution laid out that he was observed doing the things he did, which was cause death or serious bodily injury to the victim. The other people testified about their emotions and all that other stuff. And, you know, that his identity is who he is, who he says he is. So I think the prosecution's is on top right here. And I can't think of any defenses that are going to stop what the prosecution's laid out. I can't see any mitigating factors. Rain is not a mitigating factor. If you're getting wet, you can stand under any tent. If you're getting pushed, then you can use a weapon to defend yourself from a push. I just don't know that there's any case law. I don't know that the law, you know, spells out when and where. It's a question of fact for the jury. The jury has to look at the law and hear the facts and then apply the facts to the law. So it's important for the for the prosecution to get in as many facts as they can. The jury can cross all of these things. Now they're going to look at, and the only question is, was the use of a deadly weapon justified against the situation? And if we look at the situation as a whole, it doesn't appear to meet it. That physical actions of the victim towards the defendant didn't rise, in my opinion, to the level that the victim or the defendant needed to use force equal to serious bodily injury to prevent serious bodily injury to himself. It sounds like the roles were switched at one point. That at some point that the defendant, his mental state switched from being a victim to being an aggressor. He was an aggressor when he went to the place, and it sounds like he's been an aggressor through the whole thing, according to the facts. that bringing a knife was an aggressive act, not overtly, that being in a location for an extended period of time without consent or without permission was an aggressive act, that escalation of the argument was an aggressive act, and that the use of a deadly weapon was an aggressive act. And so actually you can just flip all this from him being now the victim to him now being the aggressor through the whole thing. But anyway, let me know what you think. Those are just my thoughts as I look at the facts and look at the situation. Talk to you later.